The recording has started. It's all yours, Cheryl. Cheryl, you're still muted.
Sorry. I have 5:49 p.m. Chair Schmidt, would you like to introduce the meeting or would you like me to?
If you, Ms. Leger, if you could introduce it, that would be great.
This is the Complaint Committee of the Sunshine Ordinance Task Force. This is a remote regular meeting. This is our first time using our WebEx teleconferencing system. The remote meeting via video conference is watch https://bit.ly/3N02EBY. Password is sunshine. That password will not change in the course of the hearing. Public comment call-in number is 415-655-0001. The meeting ID is 2499-517-1404 ##. Today is May 17, 2022. I will read remote access to information and participation. In accordance with Governor Newsom's Executive Order N3320, declaring a state of emergency regarding the COVID-19 outbreak, and Mayor London and Breed's proclamation declaring a local emergency, issued on February 25, 2020, including the guidance for gatherings issued by the San Francisco Department of Public Health officer, aggressive directives were issued to reduce the spread of COVID-19. On March 17, 2020, the Board of Supervisors authorized their board and committee meetings to convene remotely via Microsoft Teams and will allow remote public comment via teleconference. Members of the public may participate by phone or may submit their comments by email to cheryl.leger@sfgov.org. That's CHERYLLEGER@sfgov.org. All comments received will be made a part of the official record. Sunshine Ordinance Task Force agendas and their associated documents are available at https://sfbos.org/sunshine. Again, the public comment call-in number is 415-655-0001. The meeting ID is 2499-517-1404 ##. As the COVID-19 disease progresses, please visit the Sunshine Ordinance Task Force website regularly to be updated on the current situation as it affects the legislative process. Chair Schmidt, would you like to read meeting decorum?
Yes, meeting decorum. Any member of the Sunshine Ordinance Task Force may call for decorum due to disorderly conduct of meeting participants. Persons who engage in threatening and or menacing behavior may be asked to leave.
Okay. Item number 1. Are we ready for item number 1, Chair Schmidt?
Yes.
Item number 1, call to order, roll call, and agenda changes. Roll call. Member Wolf.
Here.
Member Wolf present. Member Stein. Member Stein present. Chair Schmidt.
Present.
Chair Schmidt present. We have a quorum. I am not aware of any agenda changes. Have committee members received any notifications from members of the public or parties of regarding agenda changes? I am not aware of any.
Not that I know of.
Member Stein, how about you?
Not that I know of, no.
Okay. And Member Wolf?
I really haven't had a chance to review the agenda. I'm sorry, because I didn't get an invite for this meeting, so I wasn't prepared. Okay, thank you.
Okay. Shall I read item number 2, Chair Schmidt?
Yeah.
Item number 2, approval of the April 19th.
We should probably give a chance for public comment on item 1, just in case. And just as a learning curve for everybody, at this point in time, when we call for comment and so forth, or call for speakers, you will need to raise your hand so that I can recognize you and figure out who you are. So if you're on the phone, you can press *3. If you're on the application, there's a little hand towards the bottom of the screen which you can push. I have one person with their hand raised. I'm not sure if they want to speak on this item. I'm going to go ahead and unmute you at this time.
Yes, thank you. We're talking about call to order.
Yes.
There was some talk about difficulty, and I certainly had difficulty with the meeting. I
Mr.
sent folks.
Warfield,
Okay.
Mr. Warfield, I'm going to ask you to stop because are you making a public comment now?
Well, you were discussing the difficulties of getting going, and I just wanted to say yes. It's listening to silence for 15 or 20 minutes is disconcerting, to say the least.
Okay.
Not to fault you, just to say that's the experience, complete silence.
Okay, Mr. Warfield, we just noticed public comment. That's why I'm asking.
What public comment?
Let me interject here, please. I did go on, I did log in, and I did make the announcement that we were getting ready, and we were a little bit late. You probably didn't hear that when I logged in, but we did start about 15 minutes late. I did make that announcement at about 5:30, and it took us a few minutes to get everyone logged in, and we understand it was a silent line until we got started, but it's something we will think about. And if you don't have any public comment on item 1, could we possibly move on, Chair Smith?
Yeah, if there's no public comment on this, we may have some glitches here along the way. Let me just ask that people be patient and just keep in mind that everyone's going through a little bit of a different system here. And we did have a delay getting everyone into their roles, into their situations here. But yeah, let's go ahead with number 2, item 2.
All right. Item number 2, approval of the April 19, 2022 Complaint Committee meeting minutes. I have a copy of the minutes. Does anybody have any suggested changes or?
From me.
None from me. I'm ready to listen to any public comment, and I would move that we approve.
Okay. I'll second that.
Okay.
Member Stein.
Are you ready for public comment at this time?
Yes.
Okay, one moment. I'll unmute our first caller.
Yes, please. This is Peter Warfield, Executive Director of Library Users Association, Library Users 2000.
Please stop talking. Are you making public comment now?
Yes, isn't that what you called for?
I have to find out who's waiting in the queue to make public comment.
Cheryl, if you don't mind me, there's no more queue. There's no more verbal queue anymore.
All right. Well,
I have the caller list. As soon as they start speaking, just start the timer and take their name.
Okay, that's what I was trying to do. If Mr. Warfield wanted to speak, that's fine, but I have to start the timer.
Okay.
Well, just so you know, the system said you've been unmuted, and that is usually the signal in other meetings that there's your 3-minute start time.
Yes. Mr. Warfield, just please give us some time to get used to it. This is Cheryl's first time using the system, so please be patient with us as we get.
I am patient. I'm just saying, please don't dump on me for speaking out of turn when I try to speak in turn.
I was very polite when I said, please be patient and give us a moment. So, Cheryl, if you're ready to start the timer, please do.
All right, Mr. Warfield, are you ready to begin?
Yes, and as I've often said previously, just let me know when you'd like me to start.
Go ahead, sir.
Thank you. This is Peter Warfield, Executive Director of Library Users Association, Library Users 2004 at yahoo.com, and P.O. Box 170544, San Francisco, California, 94117-0544. I give this information about how to get in touch because we're not in an in-person meeting, and because people may want to get in touch with each other in a public meeting, and in a real public meeting, in an in-person public meeting, they can do so. pretty easily by basically stepping up to each other and speaking. Liked what you said, disagreed with what you said about this, maybe you'd like to know something, and so on and so forth. That's not possible in one of these remote meetings unless you do something to make that happen. With respect to the minutes, there are some, aside from the request to include what I say that I say is important, there are some improvements that I would like to suggest. On item 6, my comment is noted as, well, it's not comment 6. On number 7, there's a comment about duplicative. It says, Peter Warfield noted that duplicative issues and rules concerning them have for a long time been a serious problem left to the Sunshine Task Force to not really deal with. Well, the Sunshine Task Force has dealt repeatedly with this question, and I said that it's a very problematic matter, because how do you define duplicative? Is duplicative somebody? It hasn't been defined, let's put it that way, and that is very troubling, as well as how and who decides whether something is duplicative. Is it the same person making another complaint? Is it the same person making another complaint against the same department? And so on and so forth. It may be that departments are doing repeat violations. Does that mean that nobody can file a complaint about the same kind of violation at a different time? It needs to be defined, otherwise it's chaotically undefined and problematic for everybody, and especially a complainant. There was a comment that I made that didn't sound very clear, number 9. Peter Wolf has stated, when the petitioner makes requests for violations to be found and why you are not specifying those things but not to others, wants it to be clearer exactly the reason why you have not determined those in your motion as possibly less or insignificant. I don't think that makes much sense, and I think that that needs to be reviewed to have it make whatever sense I had at the time. Thank you very much.
Okay, thank you.
Okay, there is nobody else in line for public comment. I will just give it a moment. If you would like to make public comment, raise your hand. It's *3 if you're calling in, and there's a little hand button if you're in with our application. Okay, I do not see anybody else. That completes the public comment list for this item.
All right. So, members, any thoughts before we vote to approve?
No.
Okay.
Approve what?
A minute.
The
Minutes. Okay. Yeah. Sorry.
I think that we probably substantively should go ahead and let's go ahead and vote on this.
Okay. Chair Schmidt?
Aye. Chair
Schmidt, aye. Member Stein?
Aye.
Member Stein, aye. Member Wolf?
I'll say aye, but there wasn't was there a maker in a second?
Yes.
Chair Schmidt moved to approve the minutes, and Member Stein seconded that motion.
Okay, somehow I didn't hear that. Okay. Yes, I approve.
Okay. Moved by Chair Schmidt, seconded by Member Stein to approve the April 19, 2022 minutes. Okay. Are we ready for the next item?
Yes, please.
Item number 3, public comment. Members of the public may address the committee on matters that are within the committee's jurisdiction, but not on today's agenda.
Are there apologies? If you would like to make public comment on this matter, You can raise your hand by pressing *3 if you're on the phone, or hit the raise the hand icon if you are connected to us via the application. We have one caller in the line so far, and just so you know, I'm just going to try something new. Cheryl, if you can let me know when you're ready to start the timer, and I will unmute I will recognize the person and they will be able to begin. And as soon as you, well, he's already unmuted, so whenever you're ready, you can indicate you're ready, and Mr. Warfield can begin his comments.
Okay, I am ready. Mr. Warfield will have 3 minutes. Mr. Warfield, are you ready to begin?
I'm ready whenever you say to go ahead.
Go ahead, sir.
Thank you. This is Peter Warfield, Executive Director of Library Users Association, Library Users 2004 at yahoo.com and at P.O. Box 170544, San Francisco, California 94117-0544. I would appreciate, Mr. Chair, if you would enable people to speak or to respond to things without having negative characterizations like impatient. Whether somebody's impatient or not, they're speaking. And maybe what they say is valuable, useful, or important, or not if you don't think so. But for example, technical problems, I was just describing what you were talking about. And I am patient. I am not happy when I'm sitting there for what seems like more than 15 minutes not knowing if I haven't gotten into the meeting. There's nothing, for example, when the Board of Supervisors hasn't started yet, or at least when they're taking a recess, there's something continually streaming and visible to those who have access to a computer. If you're on the telephone, you have really a second-class service, and I think some consideration ought to be given for that. I did not hear an early mention. I was going somewhere to find how to get in touch with anybody I could to see if there could be something done, as the Board of Supervisors during regular hours has a person at the desk to help out, and I've had help at times when things were not working properly. I wanted to say in general that I hope that there's some consideration for improvements to the whole way that the complaint process and the whole task force functions. One of the things I think is important to have the latest information. I don't know where to get the latest information on restrictions or easing of restrictions on the law. The mayor, I think, has had some 45 opportunities for, changes. At the state level we've had, and so on and so forth. I think it would be really helpful if there was a really up-to-date place where people could understand, and maybe you would discuss what's the latest. The website, though we're talking generally with complaints about the Brown Act, the Public Records Act, and the Sunshine Task Force, there is generally no, there isn't, as far as I can see on the website, any version or any link to the Brown Act or the Public Records Act. And I also think it would be really valuable if there was some assistance for people who might be complaining to be able to understand what the law is and how it might be applied, or how it has been applied at the Sunshine Task Force. And while departments have 24/7 access to lawyers, complainants or members of the public
Your
just
time
don't.
is up, Mr. Warfield.
And it would be helpful. Thank you.
All right. Thank you.
Do we have other public commenters?
That was the only caller for public comment that has raised their hand. That completes our list.
Okay, so public comment, general public comment is concluded. Let's go on to the next item.
Item number 4, file number 22054, complaint filed by Stillian Bazansky against Deborah Liu and the Treasurer and Tax Collector's Office for allegedly violating Administrative Code Section 6721 and 6725 by failing to respond to a public records request in a timely and or complete manner.
Okay.
Give me a moment. Let me try to find out who excuse me, if you are a party to this item, if you could raise your hand, I would appreciate it. Sorry.
May I just
Hello,
say something?
caller. Give me a moment. Hello, caller 9. Caller 9, are you a party to this matter? Are you representing the treasurer tax collector? Nope, they just hung up on me. I'm going to go to the next person raising their hand. Caller, I just unmuted. Are you representing the treasurer tax collector?
Yes, this is
Okay.
Deborah Liu.
Thank you very much. I'm just trying to get you into the right place.
And I don't know if you could hear me, but this is Catherine Sachs. I'm also with the Treasurer and Tax Collector's Office.
Okay, thank you. I have unmuted the correct people. My apologies. Please proceed with this item. Thank you.
Is Victor, do we have the petitioner present?
Yes, I believe I have unmuted their line and they should be able to hear you.
Okay.
Mr. Stillion?
Yeah.
Yes.
Yeah, they can hear you and the mic is unmuted.
All right. Now, for the petitions that we will be looking at today, just to sort of sum up what we do and what our limitations are, this is a complaint committee meeting. This is not a full task force meeting, and so we have a somewhat limited role. What our general goal is to figure out if we want to send a case forward to the full task force. We may make a recommendation. We may not make a recommendation. We generally try to find if there is jurisdiction, and if the case, we want to verify that the case does involve public information, public documents, but we don't make any final decisions here. That is left for another meeting, which is a full task force meeting. And so with that in mind, what we will do is we will give each of the parties up to 5 minutes at the start. You don't need to take the whole 5 minutes, but that's the limit to tell us. We've for the most part read your documentation already, but explain what you want to say about your case. And we will start with the petitioner first. So when Cheryl's ready, we will hear from Mr. Bajanski.
Mr. Bajanski, are you ready to begin your testimony?
Yes, I'm ready.
Go ahead, sir.
Okay. So I want to point out that there was some kind of miscommunication during the complaint submission process. I submitted a total of 2 complaints, and I asked Cheryl to split them into 2 different complaints because they were involving 2 separate PRAs. Anyway, I will proceed speaking about complaint that involves public request 21-2100, since this was the headline of today's Sunshine Ordinance Task Force meeting. Although the rest of the request kind of talks about and deals with different PRI, which is kind of confusing, but anyway. There are 2 primary reasons I submitted this complaint. First, I have submitted request 21-2100 back on April 7, 2022. And as per the guidelines of the Government Code 6253C, the maximum allowed time to comply with this request is 24 days, which means the due date was 1st of May, but since it was on Sunday, the actual due date was Monday the 2nd. Since the file was still open on May 4, 2022, I decided and proceed to open a complaint with the Sunshine Task Force. And the second reason I submitted this complaint is that I received a very valuable information from the tax and treasurer team, which otherwise I cannot find. For example, from the last episode of Sunshine Ordinance Task Force Complaint Committee, we have learned that from Deborah Liu that I have propounded a total of 11 PRI requests and 8 sets of civil discovery. I'm wondering as of now how many PRI requests I have submitted and how many sets of civil discovery I have requested. Also, Ms. Liu mentioned that someone is retiring from at the department, but at the same time they are in process of hiring a new person. So I'm wondering whether they were able to hire that person so I can expect a better performance from their team in the near future. Thank you so much.
All right, thank you. Before we go to the respondent, there does seem to be some either confusion or disagreement about whether we're dealing with a petition, or when I say petition, that's the statutory language, petition complaint, a complaint dated April 7 versus one versus dated April 20th. And one of the things that I thought might tell us the answer to that is that when I'm reading through the file, the way I see it, it looks like we're dealing with the request that asks for documents up until April 20th. Cheryl, can you give me any kind of enlightenment on what the operative date might be?
The date when the complaints first came in?
Well, it seems like Mr. Bajanski's saying that there's an April 7th complaint.
He has a couple of complaints.
Yeah, and so when I noticed in his paperwork, he is discussing the complaint of the 7th, but in the description of the matter, it seems like the complaint that's actually formally before us here today appears to be one that was filed on April 20th.
Correct, they're mixed. Basically, we have the headline of the one complaint with the body of the other complaint.
Yeah, and I that at least because we work off of what we've set out in terms of the notice, I see that I'm looking at the second page of what we got. 22054 is about a request for documents between April 1 and April 20th. And then I see that Mr. Bajanski is talking about having filed something on, or having made a request on April 7, and it was apparently, he's saying, late, the response, and yet I believe that the respondent says that it's not their March 3rd response is not late because it's a response to an April 20th request. I'm not quite sure,
I got the response to the request involving this complaint on Thursday the 12th. That's last week at 5 minutes to 5 in the evening.
I meant the response that was given to him, not the response that comes into us, because we have,
He was CC'd.
Oh yeah. What I'm saying is that we would have gotten a submission that comes to the task force, but that's in addition to whatever the treasurer, tax collector response had already been, that would have gone out to Bajanski in response to his public records request. Yeah, I think there's a little bit of, I don't know if the members have any thoughts on this. It seems like there's, in my mind at least, confusion at this time.
I will say I found the files confusing somewhat, and I'm going to tell you how I parsed it, and I'm hoping Mr. Bajanski can tell me if I am correct or not correct. Maybe that would help. But I think there was materials mixed up kind of in both files that were for different cases. But as I understand it, 22054 concerns a request for information about emails that were exchanged between April 1st and April 20th, and that what's concerned there seems to be is providing information, like not providing it in a timely manner because it was an IDR request, an immediate disclosure request, and a complaint about a private email not being redacted. And then for the second case, the way I parsed it was, this is for file number 22024, I assume that this was a separate request made on, I think it was April 7th, for documents that were produced or created between February 16th and April 6th, and that this is a complaint about, again, information not being provided in a timely manner. Is that correct, Mr. Bajanski? That was my understanding, and I'm just not sure it was correct, I guess. So I feel like if he says it's correct, then I think I can hear these cases. And if it's not correct, then there is more confusion.
Thank you, Member Stein. That's helpful. Let's hear from Mr. Bajanski if he has any clarification on that. Mr. Bajanski, are you there? Let me just first ask that.
He's there, but I can see his microphone is muted.
Are you muted? Oh, he may be muted.
Sorry, I don't remember muting myself. Yes, I'm here.
Okay. Yeah, just we didn't hear anything after Member Stein and I spoke.
Can you tell me, if my understanding is correct?
Yes, you get very complicated, but essentially it's very simple. There are two violations. One is for time constraint, and the second one is for privacy.
Okay, and is the privacy one related to, is that the April 20th
yes, correct.
request?
Correct.
And then the one about lateness is the April 7th.
Correct, right.
Okay. So I think I'm clear enough then.
Yeah, just more complicated. You made it sound more complicated. It's just less simple.
Well, I know that we can hear and decide on the April 20th item because that seems like it's properly noticed. But I think that Member Stein said that there is a separate case that's under a different number, 22024, and I don't think that's it doesn't seem like that's properly before us. It's not in the agenda. I just see 22054 in my agenda. So I don't know if
Wait, what am I? I'm sorry. Yeah, no, I read wrong. So yes, it's only 22054 that we have in front of us.
And the reason for that is because Mr. Bajanski wanted after I had sent out the notice of appearance, the cases that were going to be heard, he got in touch with me and said he wanted his cases heard on separate dates, not together.
Okay, so should we just listen to the one that's April 20th, that has to do with privacy issues?
Well, the headline is for the other. So if you read the main complaint, it talks about violation of timing constraint, and you want to discuss something else. I mean, it's up to you what you want to discuss, but I look at the headline, it says violation of timing. So it's 6453C, I think.
Yeah, I'm thinking, okay, there's a let's just go by the dates of the requests. I believe that we're talking about two requests.
Mm-hmm.
One was a request made on April 7th, and another one was a request made on April 20th. Now, Member Stein, which of those do you believe we should be hearing today?
Well, I felt like the respondent responded to the one having to do with April 20th, correct? So that one we could definitely hear.
Okay, and that would be my understanding too.
Yeah.
Cheryl, do you have a understanding of which of those two requests we should be addressing today?
I thought that we should be addressing 22054. I thought that was what.
So you don't have a thought on which of the two dates? Because I believe that there's two separate requests that he made for treasurer tax collector records. And I will ask the respondent in a moment to clarify. Let me ask Mr. Bajanski, which one of the two, or do you believe that we should be looking at both of those? Which do you believe that that we should be talking about here today, Mr. Bajanski?
The headline in the agenda of the Sunshine Ordinance deals for the one from 7th. That's why I decided to respond the one from 7th.
Okay, and now I'll go to the respondent. With that, but before, I'm not taking your time away here, but I think we need to do our housekeeping here first. Which of those two requests, if my understanding is correct, that there are two different requests, do you believe you're here responding to here today, to the respondent?
Are you talking to me?
Yes. Just, is it the one on the 7th, or is it the one on the 20th, or maybe do you believe that you're here to talk about both of them?
Well, quite frankly, I mean, you're not going to like what I'm going to have to hear, but I don't think you have jurisdiction because of the incongruency that you have. Legally, or in a rule of a court of law, they would look at the notice of the complaint, and in the notice here, it only addresses a complaint of timeliness. But I had a confusion and it was ambiguous. So I asked Cheryl, what's going on? This doesn't make sense. And she said, well, it's both, the complaint and violation of right to privacy. But that's not what it says in the notice. Then when you look at the actual substance, all the complaint has to do with a violation of privacy. But we did address timeliness and the right of privacy because you can't fight City Hall.
Okay.
Can I just follow up with the respondent? Were you responding to a complaint about records that were requested for records between April 1st and April 20th, or a complaint about records requested between February 16th and April 6th?
Page 22 of the documents, we were responding to the PRA that was for the Gmail of bajansky@gmail.com between April 21st, 2022 and April 20th, 2022. But that doesn't
You mean April
cure
1st? Okay, got it.
April 1st to the 20th. But what I'm telling you as if this were in court, you would have no jurisdiction because the notice is defective. But that being said, you know, we responded to the April PRA.
Okay. Well,
You know, but this is, like I said, we're going forward, but it is a violation of our due process, and to know what charges are being assessed against us. I just put that out there.
Yeah. Well, I think that one thing we can decide, well, I would suggest we decide is that we're just hearing the matter that involves the request of the 1st to the 20th, because I think that the notice looks like it, and several, I think the members are in agreement about that. Member Wolf, did you have any thought on which one of these we're dealing with? I don't. Okay.
Sorry, Schmidt, didn't Member Wolf say he's like here, but he didn't receive the information, the packet, or the agenda?
Okay.
So
okay.
I don't think he would know, but.
I do have a concern about what we just heard from Ms. Liu in terms of they didn't get notice that this is about these allegations regarding privacy. I'm not sure if I believe we need to continue the issue of 22054 as noticed, because I know that these are privacy allegations, but I think they are discussed in the response. So I think that my understanding is that they were aware. So at this time, I'm going to say that we're gonna only handle the complaint that involved emails, the request for emails from the 1st to the 20th. We're not going to deal with the one that goes from February something until April 6th. We're not going to make any decision on that here today because we didn't get that far. And with that in mind, Member Stein, is that all right with you?
Yeah, I mean, I think that is the correct thing. I think the respondent did understand that in the main, that we were talking about the complaint that was made in relation to the April 1st to April 20th emails. And I think they did understand that the complaint had to do with personal email information not being redacted. So I think, and they addressed it in great detail in their response. So I'm comfortable moving forward with that, and just making sure that we hear this complaint about documents produced between February 16th and April 6th later.
Yeah.
Yeah.
And to the respondent, and I'm going to give you your chance in a moment here. One of the reasons I think we can handle this and consider advancing it to the task force is we want to save your time in addition to anyone else's. And this allegation of sort of like over disclosure, I just don't know if that's going to really even come under any kind of disclosures that you made to Mr. Bajansky were to Mr. Bajansky. So I don't see how there's really going to be a viable privacy violation allegation. But that's just part of my reasoning why I think we should go ahead with hearing this thing. So with that in mind, when Ms. Leger is ready, now Thank you for your patience with me. We will hear from the respondent side.
You mean the petitioner first?
No, we did hear already from the petitioner. We heard from Mr. Bajanski.
All right.
Respondent.
All right.
Okay.
May I ask who's speaking?
This is Deborah Liu
Okay.
for the Treasurer and Tax Collector's Office.
Okay. Ms. Liu, are you ready to begin?
I am.
Go ahead.
First issue that was raised, at least by the Sunshine Task Force, is the timeliness. As indicated in our papers, the purported IDR was propounded to us on April 20th. We immediately asked our IT team to pull the documents. There were approximately 630 potential documents to review. So the very next day, we advised the petitioner that this was not an IDR, but we would handle it as if it were a standard PRA. And we said that we would respond, by May 2nd, which was the 10 days, and we actually provided all documents by April 29th. The second issue that is should be part of the petition that we weren't noticed for is that we violated purportedly his right of privacy by having some of the emails live when we did the redaction. As indicated, we need to confirm our obligation in this because the petitioner put his own email address into play. He made it as part of the request that's on page 22, where he's asking for the all emails with the email address bajanski@gmail.com between April 1st, 2022 and April 20th, 2022. He put it on next request, which is a public view. He emailed us and told us that he didn't care about alterations. He expressly stated on the record before the Sunshine Task Force that he was waiving the redaction of his privacy information since the responses were not being released publicly. So we don't quite understand what we're supposed to do. We tried to redact it. He complains about the time that it takes to redact it. He waives it. And I think what happened, and Catherine Sachs can explain this better, is she used the tool. It's called Rapid Review that is new to next request. So we could expedite it, and we didn't know that in certain areas that it didn't cover up, that it was live, because when you look at it, it looks like it's redacted. But apparently when you hover over it, which we didn't realize, you could see the email. But again, the email isn't really private anymore because he put it out there. This is his third complaint, and in every complaint on the agenda, the Sunshine Task Force publishes his email address. So in consideration of all of these facts, we have not violated his right to privacy. Thank you.
Thank
I
you.
should also ask if Catherine, if you have anything to say.
Oh, go ahead. Yeah.
Hi, can you hear me?
Yes.
Yes, I did want to add that what Ms. Liu was referring to is the batch redaction tool in the Next Request platform, and it allows us to redact an email from multiple documents simultaneously. And apparently what we discovered later is that it doesn't, while it does read an email address, it does not read what we refer to as the hidden mail to links. So it didn't pick those up. And when you look at the document on its face, you don't see that hidden link when just looking at the document. And that's all I wanted to add.
Okay, great. Thank you. Okay, now is the time where members may or may not have questions for the parties, for the anyone who's a witness on behalf of a party. Member Stein, any questions?
Yes, I have some questions for Mr. Bajanski. First, Mr. Bajanski, are you off mute? It looks like you are. Okay. Do you recall saying that the treasurer and tax collectors did not need to redact your personal information at the last complaints meeting in which you appeared?
I say I may or may not. That's what I
Okay.
said. So it was conditional, but it was for a different PRA. So I guess it shouldn't matter what I
Okay.
say.
Are you aware that your email address is publicly available when you make a non-anonymous request for information?
No, I'm not aware.
Okay. Can you address why you consider this a privacy violation?
Because all the other emails were redacted, and some of the documents they were not redacted.
Okay. And I have a question for the respondent. You say you say at first that you had to review 630 records, and eventually you supplied 86 records. You used auto redaction to supply those records. Can you just explain in a little more detail why, since you were since the number of records was somewhat limited and you were able to use auto redaction, why was this not an immediate disclosure request in your view? This is a question for the respondents if they are unmuted.
Okay, I didn't know if Catherine was going to respond
Okay,
or
sure.
if I should, but I guess we both can. So let me just say, initially, we saw 630 documents. We don't know what is in those documents.
And these were
And
630 documents. Wait, can I just back up? These are 630 documents produced between April 1st and April 20th?
Yes.
Okay. Oh, go ahead.
So it's kind of like those Forrest Gumps. You don't know, what's in that box of chocolates. So we just saw that there's so many emails, and it's not always just standard with, that we're going to just turn over everything just automatically, that you can do it in a day.
Okay, so
but we didn't delay. I mean, we
had to review. Go ahead. Sorry.
Yes. Ms. X can attest to what she did.
And these were just emails? You had 630 emails that over a 19-day period, 20-day period contain these keywords?
This is Catherine. It's 630 individual documents. So that could be, for example, 300 emails with 300 attachments. I couldn't tell you exactly how many emails versus how many attachments, but that's the total number.
Okay.
And so when we look at redacting an email, we also have to look at the attachments and what needs to be redacted, if anything, in those. But the part of what makes it time consuming is, as Ms. Liu said, is just sorting out what items are protected due to attorney-client privilege or whatnot, and what can be released. And then once the items are sorted, then we're able to do the redaction process.
Is it unusual to have that many documents related to a member of the public produced over?
Yeah, that would be unusual, except that I think that because we have ongoing litigation, there are a lot of potentially responsive documents.
Okay, thank you. Those are all my questions.
Okay, no questions for either party from me. How about Member Wolf? I'm not sure if Member Wolf still is in the meeting right now. But unless there are questions from Member Wolf, we can move on to figure out what we want to do with this case. Member Stein.
Sorry, I just want to say I don't see Member Wolf on the attendee list anymore, so I don't think he's still on. But someone can correct me if I'm wrong.
Yeah, I guess he stepped away. So got it.
Yeah. So I mean, my inclination here is that obviously these records are public; they're under our jurisdiction. But I don't think his email is private information, and I think there are reasons for that, including that we do make it clear in our own documentation that if you are not making a request anonymously, that any personal information that you submit may be, seen by the public. And I do recall a meeting where Mr. Bajanski said that he would rather have documents quickly than have the agency spend time redacting his personal information. So I think my recommendation would be to forward it to the task force, but with the recommendation that they find no violation on this question of privacy, and that any references to things being late, like 67.21 and 67.25, not really be considered because they're not relevant in this particular case. This doesn't seem to be about information being provided late, unless we consider this to be a valid IDR, but it seems like properly considered, this probably was not appropriately an IDR because there is litigation, there was so much documentation, and given the context of litigation, it has to be reviewed before they can provide it. So those are my thoughts.
Okay, and I'm in total agreement with you. From what I can see, the treasurer tax collector's office did everything that I would ask of them in this situation. I don't think there's a timing violation, and I think that this issue about privacy, it has multiple problems. One is, I don't even think initially that this type of information is within the right of privacy legally. Two, I think it had already been disclosed. Three, I think that anything, if there was any kind of right of privacy, it was waived. So I'm gonna make a motion based on Member Stein's recommendation that we send this to the full task force because we have determined that there is jurisdiction. These are public documents, but we make a recommendation of finding no violation based on time and no violation based on privacy violation allegations.
Sorry, recommendation to find no violation for timeliness, and I didn't hear that second part, Chair Schmidt.
And no privacy violations.
So that's a 67.25. Because didn't he say this was an IDR?
Yeah, but I think it was not correctly. It's not appropriately an IDR. But so we're just recommending that that's what the task force do, just to try to streamline what's going on a little bit.
Member Stein, you're seconding that motion?
Yeah, I'm seconding it.
Do we want to move to public comment, Chair Schmidt?
Give me one moment. I am clearing the hand raising at this time. Oh, actually, I don't need to. If you'd like to comment on this item, you can raise your hand by hitting *3, or you can raise your hand if you're logged in via your computers. And we only have one person in line to speak on this matter. Mr. Warfield, you can begin. Cheryl, are you ready to begin the timer?
Yep.
Okay, Mr. Warfield, you can begin your comment as soon as you are unmuted.
Mr. Warfield,
Yes.
you ready to begin?
Yes. Just let me know when.
Go ahead, sir.
This is Peter Warfield, Executive Director of Library Users Association, Library Users 2004 at yahoo.com, and P.O. Box 170544, San Francisco, California 94117-0544. Bottom line, I would agree in general with sending this, with the motion, in particular with sending it to the full task force. In general, I'm not clear at all any longer what the goal is, what the purpose is of the complaint committee and the other committees that presumably review complaints. It seems to me that there was a time when there was an attempt to examine the facts of the case, clarify what the issues were, and come to a recommendation as you have done this time. But then it seemed to me that there was a period when you decided that you would not make recommendations and instead just simply send things forward to the task force or not, basically deciding do we or do we not have jurisdiction. So it's not clear to me what your role is any longer, and I certainly would appreciate a response as to what it is currently and whether it's documented in the procedures, including the complaint procedure. With respect to something that I heard more than once, and I was rather disappointed, shall we say, and that is this concept that it is up to the respondent to decide whether something is or is not a legitimate immediate disclosure request. The fact is, it is the complainant, or if you like, the requester at that moment, who makes a request and has every right, if they wish to, under Sunshine, to call it an immediate disclosure request. And it becomes that simply because they have said that's what it is. Now, if you have, as a respondent, difficulty with responding within the time allotted under the Section 67.25, then you're perfectly within your rights, under the right circumstance, to warrant an extension, as it says, of 7 days as provided by such and such a code, but it's not to be used as a delaying tactic, basically, is what the law says. So to sort of spank the public with, well, this isn't a legitimate IDR, is just simply wrong. That does not exist. And if you want to lecture people about the law, at least get it right. And to talk about this for the second time, it's not an appropriate IDR. That's just wrong. It may be something that will take you longer than the next business day to answer, but that is something I think that the task force should be very clear about, because it
Time is up, sir.
gets to lecturing the public incorrectly. Thank you.
Thank you. Okay, we can have a vote now.
That was the only public commenter for this matter.
Yeah. Let's, Cheryl, when you're ready, we can vote.
Chair Schmidt?
Aye.
Chair Schmidt, aye. Member Stein?
Aye.
Member Stein, aye. Member Wolf?
He is not present. He did leave the meeting.
Yeah, he wrote in the chat that he had to go, and because he had not been, he didn't realize he was meant to be part of this meeting, and he had already accepted to be part of another meeting.
Okay, can I just say one thing? He got the agenda when it was sent out to everybody.
That's not a discussion to be had this time, please.
Okay, I just read his note in the chat, so I'm just conveying it.
Yeah,
Okay.
it's no need to just. He wouldn't have usually been in this meeting anyway because he's not a regular part of this committee. And I know there was no discussion of whether we were going to have a third member, but it's not really that important. We have a quorum. Okay, we can move on to the next.
Shall I repeat the motion?
Oh, I think you already said what. Go ahead, Chair.
Moved by Chair Schmidt, seconded by Member Stein, to find that there is jurisdiction and the records are public, and to forward the matter to the task force and make a recommendation for no violation for timeliness and no privacy violations also.
Thank you. All right. When ready, Ms. Leger, we can hear the next case, which is 22024.
Okay, hang on a second. Item number 5, file number 22024, complaint filed by Sergei Zverenov against the Office of the City Attorney in their capacity to serve as supervisor of records for allegedly violating Administrative Code Section 6721 D as in dog by failing to provide a determination as to whether the record requested is public and in a timely manner.
All right, so we start with Mr. Zverenov for up to 5 minutes.
Yes, can the parties to this matter please raise their hand so I can identify you? Okay, I have Jen Court has raised her hand. I believe she would be a party. Is there any other parties to this matter?
And Mr. Zverenov, I think we should remind him how he would.
Yes, if you're calling in, you can press star 3 to unmute your phone line. If you are connected via a web page, there's a little hand that you can press to raise your hand. It'll be on the bottom of the screen towards the right-hand side.
Okay, let's just see if we give him a couple seconds to try to do that, see if he's present.
Okay, the people I can identify are on the phone line. If you are on the phone line and are a party to this matter, please press star 3 at this time. Okay, I am not seeing anybody else raising their hand for this matter.
Thank you, Victor. Member Stein, it doesn't appear that the petitioner is here for this hearing. What if you have a recommendation? What do you think?
I mean, we can table it, I guess, without prejudice if we want.
In a situation like this, we usually table the matter and close the file. And then I would notify the petitioner that their case had been heard before the complaint committee or was noticed, and that they have 60 days to and it will be closed, and they have 60 days to let me know whether they want to keep their complaint open or not.
Sounds good to me.
Okay.
Let's I'll move to table it, and Cheryl, do we technically we dismiss it, right?
At this point, yes, it would. Well, not yes. It's closed.
Okay.
It's closed.
We'll take public comment on the motion to table.
Table close. That's my motion.
Table and close the file, and Ms. Stein is second.
Yes, I second that.
And now we're ready for public comment.
Okay.
Yes. So at this time, if you'd like to make public comment, you can press star 3 to raise your hand, or press the little hand raising on the screen to raise your hand. We do have the respondent present today. I don't know if you want to hear from them at all.
How proper would that be? I mean, I did have questions for the respondent.
Usually, if you close the file, you don't want to take any testimony at all.
Okay, then unless the respondent has something they voluntarily want to say, maybe. I don't know.
I appreciate their presence, and they certainly, if they do wish to say something, that's fine. But I think they probably can save it since the matter's going to be I assume
Okay.
we're gonna vote for our motion dismissed.
Okay. This is last call for public comment. You can press *3 to line up to speak, or hit the raise your hand icon. We have one caller. Cheryl, are you ready to take public comment?
Yes, I am. Do we have a
Okay.
speaker?
We have one. I am unmuting them at this time.
All right, my line has been unmuted. Do you want me to start, Ms. Leger?
Yes, you may begin.
Thank you. This is Peter Warfield, Executive Director of Library Users Association, Library Users 2004 at yahoo.com. Also, P.O. Box 170544, San Francisco, California, 94117-0544. We're not a party to this case or particularly familiar with it, but I do have a concern about basically quashing information. I don't understand, and I don't recall reading anything in any kind of procedure regarding the Sunshine Task Force's procedures that says anything about not talking to the respondent or not asking questions if the file is going to be closed. Now, I would very much appreciate that there might be a reference to where in the complaint or other procedures that is said. But in general, I am all in favor of more information, and I don't see why it would harm anybody in any way to have some more information if that's what a member of the body wants. So I can only say I certainly wish that the member was able to proceed with whatever questions that he or she had, and I would be interested in where in the procedures this is stated. One of the things that happens with Sunshine is that there's a long history, of course, but that many, many, many small and not so small decisions have been made as your body went along, and not that there's anything necessarily wrong with that, but very often such kind of traditions, what you might call practices, habits, are not documented. And they come out of the blue, I think, sometimes, and smack sometimes members, and certainly sometimes members of the public. And I think that the task force should be very clear about what the rules are and what the decisions about such things might have been, and have those published every time, because if they're going to affect future matters, such as that's how we've always done it, or that's how we do it, or that's how we decided to do it last year on such and such a case, those things need to be documented. And I don't recall anything about the restrictions on what task force members can or should say to a respondent who's when the case is going to be filed or closed or tabled or anything else like that. Thank you very much.
Right. Thank you. I believe that means we're ready for a vote on this.
Chair Schmidt?
Aye.
Chair Schmidt, aye. Member Stein?
Aye.
Member Stein, aye. Moved by Chair Schmidt, seconded by Member Stein to table the matter and close the file.
Okay. So when you're ready, Cheryl, we could call the next two, and they both involve Mr. Templeton.
Okay, just a second. Getting my record ready. Item number 6, file number 22027, complaint filed by John Templeton against the Planning Department for allegedly violating Administrative Code sections 67.7, 6721, and 6729-7 by failing to post an agenda containing a meaningful description of each item of business to be transacted or discussed at the meeting, failing to respond to a request for public records in a timely and or complete manner, and failing to maintain and preserve all documents in a professional manner.
Okay, so yeah, we have two cases. They are in many ways overlapping. Planning is one of the respondents, and historic preservation is the other. I believe that they would have been basically responding to the same request, although they may have different responses for various reasons. But this first one is against the planning department, and we have read the file. Mr. Templeton, we're focused mainly on the document requests and also anything having to do with problems with public meetings, including, I know you've made a claim that people were prevented from speaking, but there's a lot of items that I see in the paperwork that may be outside of our ambit. But with that said, when Ms. Leger is ready, we will hear from Mr. Templeton first for up to 5 minutes, and then we will, after that, hear from the responding party, the planning department.
Mr. Templeton, are you ready to begin speaking?
I'm still waiting to share the PowerPoint.
Victor, can you give him assistance?
Give me a moment. I just want to ask, has this PowerPoint been shared with the task force before today's meeting?
No.
Chair, that might be a question for you, in that if a document is not submitted 5 days before the meeting, it'll be up to you to determine whether or not to accept it. This is the first time we've had to deal with this remotely.
Yes, and certainly it's appreciated, Mr. Templeton, that you're offering a PowerPoint. I'm not quite sure what it is you're asking to show us, but
well, basically, I'm distilling all the data down to the very points that are in your jurisdiction. As you mentioned, there's a lot of information in there. Okay. And so I just pulled out the things that are specifically relevant to you.
I think that well, since we're in the situation we're in that we don't make any kind of decisions here today. We basically are sort of we're taking a look at the file to see if it's ready, to look at certain aspects of the file to see if it should go to the full task force. But this is just a committee of the task force. I think that the PowerPoint is something that you would definitely want to have ready when that happens. But since we don't have it here today and it wasn't in the publicly available file, then I think we'd have a problem with complying with our due process obligations if we were to be looking at that sort of privately here on the video screen that members of the public are not able to view. So I think I'm going to have to say we can't look at the PowerPoint, but please save it for when, because any kind of distillation, any kind of summary of your case is going to be very helpful for people looking at it when the full task force is looking at the case.
Okay, well, I will deliver it in verbally then.
Okay,
we would appreciate a copy after the meeting so that we can put it into the file, and it will be available at the next meeting.
Okay. Yes. All right. Well, as you mentioned, your jurisdiction is whether they provided the public records in a timely and complete fashion. their failure to maintain public records, and conflict of interest by Richard A. Hillis and the San Francisco Planning Department. An issue which may be for the full task force and perhaps for the Ethics Commission is retaliation for the 2007 Sunshine Ordinance Task Force ruling. The Planning Department response is not accurate. They claim to attempt to meet the request by April 7th. They didn't actually begin to review the request until April 19th, 5 days after receipt of the complaint from the Sunshine Ordinance Task Force. They didn't meet the 10-day deadline or have an appropriate justification for the 14-day extension. So we originally requested the grant agreement and associated data on invisible pioneers, African Americans in San Francisco, during a meeting with Diane Matsuda, Richard Sucre, Richard Hillis, Archbishop King, Alfred Williams, Fred Jordan on November 29th, when they said they would provide the information. It took 6 weeks for Sucre to tell us in a session like this, the information didn't exist and there were no remaining staff members familiar with it. To this date, they still haven't produced the grant agreement. During the conversation, they said, well, we can just get the information from John Law with the Mayor's Office of Economic and Workforce Development. So they actually knew where to get it and how to get it. The actual document was signed by Hillis. So he had direct knowledge that the document existed and apparently had a motivation for making sure that it didn't come forward. Apparently didn't occur to him that we had a copy of it. So we had to wait until March 11th, which was almost 4 months, to request the grant agreement, which was provided in 1 business day by John Lau. So it was a 4-month denial of our Sunshine Ordinance rights that actually created tangible harm in terms of time, fraudulent misrepresentation, and lack of due process. So one of the things that we brought forward was the fact that when we did the accurate and scientific nomination for African Americans in San Francisco, we actually had a team of architects that worked with it, and we had the invoices that they submitted that were never paid by the city. And so to kind of sum up the 1,000 pages of documents, the city attempted to create a situation where inferior report that they had commissioned and tried to get us to endorse that by saying that our work never existed. And somehow feeling that we would lost our memory. As go forward, when we actually looked for the information, I went to the city archivist and asked for the agendas for the meetings, and found, as you'll see in some of the documentation, a 2-year gap in the agendas that covered the period that was in question. And so this was a period when Richard Hillis was in charge of these documents. So, so this is something else that made us very suspicious. And so after we had the problem on October 20th,
22 seconds.
Yeah.
We submitted a list of emails that we had, and the commission basically refused to investigate and chose to just go along with what the planning department said. So we basically haven't had any representation in terms of this issue, and So I'll answer any questions you might have.
Thank you. We may have questions. We're going to next hear from the responding party, and then we will move on to questions. And so when Cheryl and Victor have the responding party on, let's go ahead with
I believe that Mr. Ionin is on the line with us, and he has just unmuted himself.
Indeed. Good evening. Jonas Ionin for the Planning Department. And just for a point of clarity, are we hearing items 6 and 7 together simultaneous right now, or
No.
separately?
Separate.
Okay.
It's going to be, there will be a lot of overlap, but just 7, which is
Understood. They're just essentially the same complaint. You'll have to excuse me, but unfortunately, I tested positive for COVID on Sunday, and so I'm a little bit under the weather, so I apologize for my voice. I'll just got the complaint cites improper noticing of language on the agenda. I'm really not clear on what Mr. Templeton is suggesting that is inappropriate or was not agendized. And then with reference to maintaining records in a professional manner, we basically retain all of our records according to our record retention policy. That's all I can say to that, because I'm not really sure what the argument is there either, to be quite frank. I will address the failure to comply in a timely manner and acknowledge that a lot of our responses were tardy. Mr. Templeton cites a verbal communication request in November. I was not party to that request. I'm not saying that it didn't happen. I'm just saying the only time stamped communication that my office that deals with responding to record requests was received on March 28th of this year. So that's really the only date that I can move from. We did invoke an extension just based on the voluminous nature of the request, the dates that it spanned back to related to the request, as well as the number of staff persons involved in the request. And due to the fact that a large number of the staff that originally worked on the African American cultural historic context statement are no longer with the department. So it took quite a bit of scrubbing to collect those. We feel we have fully responded to his request at this point, but quite honestly, I'm not going to argue that we were late to respond. I really, quite honestly, plead no contest to that. I'll just stop there because again, I'm not clear on the failure to post an adequate agenda or retaining records in a professional manner. So I really don't know how to respond to that. So I'll pause there.
all right. Thank you. So questions for the parties, and we'll start. Member Stein, any questions for the party?
Yes. Hold on a second. I need to clarify a little bit. So I have some questions for the petitioner and for the respondent. For the petitioner, the only records request, you mentioned in your opening statement that you were trying to get a copy of a grant agreement. And you said you were told it didn't exist, but eventually it got produced. But the request that I see in your file is for 6 different things, really. For notes, messages, memoranda related to October 3rd, 2007, notes, messages, and responses related to a November 2015 event, something from 2018, something related to 2021, and then something related to October 6th and 20th, as well as financial records relating to a 2012 work order from the Historic Preservation Fund Committee. So I just want to clarify, are those 6 items, that's what you requested, or that's what this request is dealing with?
The original discussion on November 29th was to get all the records relating to invisible pioneers, and that's what they did not act on, and for the most part have not acted on to this point. One of the issues that is worthwhile is that this matter came before Sunshine Ordinance Task Force in 2007, and it was because of a ruling by the task force that the grant agreement actually moved forward. And in my first amendment, there is a 4-page article in the Chronicle that describes the dispute that was happening at the time. But in the materials that was provided, there's very little evidence of the discussions that happened. And for instance, the ruling said that the reason that they moved a meeting where we had commissioner from the Historic Resources Commission and 4 National Park Rangers was because of the receptions. And so, it would have been very interesting to us to see what the rationale and what the arguments were for that internally. And so, so it's all kind of related to, the effort to hide that.
Okay, I'm still confused.
Sorry.
The information requested, there's that, it's like the 5 different sets of documents around different things that happened, right? And then the 2012 work order. What is this discussion on November 29th? What is that? Is that a different request? Or I'm just confused about what request are we looking at in terms of trying to figure out what documents they provided and what they didn't provide. I understand
the March 28th was a follow-up on that original request.
Okay, but the documents that are being requested are documents related to a National Register tour of National Register candidates, right? Related to an event called Teed Up, related to your book showroom, related to the planning department, a panel discussion of planning department employees, and that list, right? Is that the documents that we're talking about here?
Well, there's also an additional request that we made for additional information. So there would be 3 requests in November, in March, and then again in April.
Are those all in this packet?
Actually, yeah. Mm-hmm.
Okay, I guess maybe someone can help me refer to the Invisible Pioneers project. I saw you talking about it in the packet, but I didn't see the specific request that was made to them about it. So I guess I'm a little bit, maybe it was,
Well, like I said, there's a lot in there. And
there was a lot of stuff.
It actually took me a while to figure out what was going on. So I certainly.
So what material have you still not received that you want?
We hadn't gotten any of the financial data. I saw a email that came in today, but as you mentioned before, it came in after the agenda. So I have no idea what's in it. I think there was also something came in Friday, but anything we've gotten we've only gotten materials after, we've first got materials after the complaint was sent by the Sunshine Ordinance Committee. That's the first time we got materials. And then the second time we got materials was after you noticed the hearing. So,
okay. That's all these on the request that I definitely saw, which was for like, 5-6 different items,
Yeah.
those are all related to the Invisible Pioneers project, correct?
Some are, some aren't. Part of the issue is one of retaliation for the original Sunshine Ordinance Task Force ruling. So there's a continuum of activities, and there were some things that we saw in the material that we had forgotten about. So that raised other questions.
Okay, and then I have some questions for the respondent. Thank you, Mr. Templeton. For the respondent, can you describe your search process for these documents? And particularly, I saw that you gave or responded and felt that you gave documents related to number 4 and 5 in the request, which was memoranda relating to September 29th, 2021, and a panel discussion, and then memoranda and notes related to October 6th and October 20th. But I didn't see any evidence that you had responded to items 1, 2, and 3. So could you describe your search process for items 1, 2, and 3, which had to do with the 2007 tour of National Register candidates, a 2015 teed up technical fouls make proposed warriors, or notes related to a teed up event, and then notes related to 2 planning department employees visiting Mr. Templeton's book showroom. Can you tell me about searching for those documents and whether you've provided them or not?
Sure, I'm going to try to pull up those. Those items so I can address them specifically. But as I'm pulling them up,
sure you get some chicken soup while you're there.
I'm sorry.
Make
Did I
sure you get
interrupt
some
you?
chicken soup.
What is it, Victor? We can't hear you.
I wasn't stating anything. I was muted.
Oh, okay.
I think Mr. Templeton was accidentally not muted, but
Mr. Templeton, did you want to say something?
Oh, I just wanted to encourage you to get some chicken soup.
I just had a bowl. Thank you very much.
Fantastic. Great.
Okay. So items 1, 2, and 3 are essentially requests for notes, messages, and memoranda related to specific occasions. And so essentially what we do is we query our staff who are actually still on staff. The first one was from October 3rd, 2007. The second was on November 2015. And then the third was 2018. So we have, unfortunately, had a lot of turnover, specifically in the Historic Preservation Division of the department. And as previously stated, there's a large number of those staff that previously worked on these matters that are no longer with the department. Notes, messages, and memoranda that are not substantive to any specific application or case are not subject to any kind of a retention policy. So without those planners physically present who may have retained any notes, memoranda, being absent, we exclude essentially all of those persons, and we are left with those persons present. So essentially we send out an email communication to those people that we feel may have those records and request that they provide them to us.
okay. And no, there was nothing else done besides that. Like you didn't go to IT and ask if they could search.
Well, because notes and messages, they're generally not electronic documents that are retained. However, we did do a background search for emails with Mr. Templeton's name on them to discover those, and those were made part of the record for Mr. Templeton.
And can you just tell me what is your record retention policy?
Related to?
Related to records produced by your agency. Like,
well, there's a variety.
For instance, if you have grants contracts with people, like how long do you retain those?
Yeah, the record retention policy cites generally no retention, meaning we don't have to retain them at all until they've been the project has been processed and is done 2 years or up to 5 years. Our practice is actually better than our retention policy dictates. We generally don't throw things of any substantive nature away when we close our documents. And today, especially when most things are actually submitted to us electronically, we don't, for example, in practice, destroy documents.
So you keep project records for, you said 3 years?
That's the requirement, yeah. Upon completion, that's the record retention policy is what it says. But as stated, our practice is actually better than our policy. That what our policy requires of us.
Okay, those are all of my questions. Thank you both.
Okay. I do see that Member Wolf is in attendance, and if you had any questions, go ahead and raise your hand. Okay, good. I just have a couple. We start a couple questions. You mentioned a meeting that took place in November 2021, and that there were, this is I believe it was a historic preservation meeting.
No, yeah. If I could give you a timeline,
there were people denied the ability to make public comment.
That was October 20th.
Oh, October.
That was an actual meeting.
Okay.
So then we had a meeting on November 2nd to address that. During the November 2nd meeting, the topic was raised to us by the chair of the commission that there was an African American context statement that they were working on, to which we replied, well, we already did it 15 years ago and you haven't acted on it. So she said, well, I would like to see it. And so on the 29th, because we were concerned about what so often happens to Black businesses, where people just kind of take your content and move on, we gave them access to it online with a password and said, okay, we will let you look at it. And in the instructions, as you'll see in the packet, we made it very clear what the understanding was in the November 2nd meeting. Because she said, if this document meets the Secretary of Interior standards, I will call a meeting in January before my term ends as chair of the commission to hear about it. And so that there wouldn't be any misunderstanding on the email where we sent her the link to it, we said, we are providing access to this for the specific purpose of determining whether you have the meeting. And so this would go to the question about proper agendizing, because in the October 6th and October 20th meeting, we requested in the public, to have the commission hear Invisible Pioneers. And so this was the direct request that we made. So this was her response to the request that we made in the public comments. The issue for us was that the first public comment, we had 3 minutes. The second public comment, we couldn't even get on. So having it on the agenda didn't require them to approve it or anything like that. It was just put it on the agenda so we have enough time to discuss it. Right? And so she said, okay, if I see it, I'll do it. She looked at it, said, oh, this is better than the one we did. So that's kind of where we are, where this representation wasn't followed through on. And we were then presented with a take it or leave it offer of, or we'll give you some crumbs to do outreach for our document. And it's like, well, wait a minute. Didn't you read the op-ed in the Chronicle where I said your document had no scholarly merit? So that's kind of where we are, where there was a, suggestion, representation, whatever you want to call it, to hear about our document, which has never had due process. And the significance of the grant agreement was that we had a grant agreement. We had to go through 2 years of hell to get to the grant agreement, and only got the grant agreement because of the Sunshine Ordinance Task Force. And then after we got the grant agreement, they never paid us. So we spent 3 years.
I just want to,
and that's beyond your scope, but I just want to give you context.
Sure. Yeah. Thank you. I want to just really be specific because this is part of the text of the complaint that we get, which is that there was an October 20 meeting, and you've said that 3 people apparently were not allowed to make public comment.
Yeah, we tried to allow going just like today, and we couldn't.
You one of the 3 people?
Me, Dr. Amos Brown, and Al Williams.
Okay.
And I got emails where they were emailing me and saying I can't get on.
Okay, so this was a situation where it was a commission meeting, correct?
Yes, and this was public comment.
Okay, and it was public comment, and as you understand it, their system was set up in a way that all 3 of you did everything you needed to do to try to get in for public comment, but you were not able to make your public comments.
That's right.
Okay.
And if you know anything about Dr. Brown, he's never shy about making public comment.
Absolutely. Now, the November 29 meeting, you've said that documents were requested at that time.
Yes.
And I know we have a very clear record as to what you requested later in I think it was March 28th. But back in November, who made a request for documents and who did they make it to?
Okay. Richard Sucre and Diane Matsuda. So after she looked at the online file, she suggested a path forward. And we said, well, the first thing you have to do is to settle the grant agreement. And they both said, oh, well, we'll have somebody look it up. And then they said, well, it's the mayor's office, so we'll call John Lau, and John Lau will get it. So nobody did that. So it was March before 4 months passed where I finally called him myself, and he gave it to me in a day. So they could have got it in a day.
Okay, so they
like I did.
they promised you that they'd give you a copy of the grant agreement. Right?
Well, it wasn't for me, it was for them.
Okay, but now, but I think you've been saying that. Okay,
I mean, I made the request, but I was requesting it. So they were basically questioning whether it happened. I said, okay, well, go get the document, and so okay. It was, they agreed to access that document.
But did you already have a copy of the grant agreement?
I actually didn't.
You did? Okay, no. But you were waiting until March to get a copy from them?
Yes.
Okay, got it. And they promised to get that to you during that.
Well, but in between, on January 10th, Sucre said, well, our people are gone. I didn't feel like looking for it. It doesn't exist, right? So basically just blew it off. And that's when, we said, well, I know it existed. So that's when I went to the public library, and that's when we saw the 2-year gap that covered the whole period of furor. And that's when, we went directly to the mayor's office.
Did you get a copy of the grant agreement at some point?
Yes, from mayor's office.
Okay. And that was in April, I'm guessing.
March.
Oh, in March. Okay. Okay. Got it. All right. I think that answers the question I have for you. I have a question.
And the consequence of this is that we were promised to have the meeting before Black History Month, because our proposal was to basically hold community events during Black History Month when everybody was, interested in the issue, and the Historical Society had a whole robust thing. So because, we never got the information back, we didn't have the opportunity to move forward on that. The other thing is that for the past 14 years, we've done a 7-week course on Black history in California. So that 7-week course not only would have been good in terms of community outreach, but it was something that we recommended for the staff, because as he mentioned, he's had turnover. And so one of the things that became very obvious to us was that the staff knew nothing about the Black community. So it was, irresponsible for them to even attempt to do a context statement, because they don't even know where the 22 runs.
Got it. Okay. Thank you. A question for responding now. On April 21st, from your department that we're still working on the request.
Can we pause slightly? We are having some volume issues.
Yeah, Chair Schmidt, I'm sorry, you're going to have to repeat your question.
Yeah, I apologize. That was my fault. On April 21, and this is in a document that was submitted to the task force, you said that you're still working on responding to the requests. And I wonder if that's, as of today, is that what's going on? Is that people are still looking for documents? Or have you, was there any document that were obtained in that 1 month between the 21st and today? And then are there any documents that you're still looking for at your department?
As of today, we feel that we have fully responded. The document that we were trying to locate was the contract and the work order for the between the Planning Department and the Office of Economic and Workforce Development for the African American Historic Context Statement that was requested. And that was a contract that I believe we just submitted to Mr. Templeton yesterday, in fact, because we had to first go through our internal administrative and accounting department to see if they could locate it. It turns out it was finally discovered in an off-site storage location where we had to order that document, and it was finally retrieved and provided to us. And so that was provided to Mr. Templeton yesterday via email.
Okay. And your understanding is that at this time, you've looked for pretty much everything that was asked for, and you don't anticipate that there will be anything else that can be located that would be responsive.
At this point, we've done a comprehensive search for all of our documents. That was the one outstanding document we felt that we should have, and we were finally able to locate.
Okay, thank you. No further questions for either, and I guess at this point, again, we're just trying to figure out what to do with the case. Do we send it to the full task force to hear? We're doing some fact finding here today, and so now it's time for the members to talk about what we want to do next with this.
Chair Schmidt, if I may interject, I just want to make a comment to Mr. Templeton regarding his accusation that he and two of his colleagues were not permitted to speak under general public comment at the October 20th hearing. I'm the secretary to the Historic Preservation Commission, so I was at that hearing. And I just wanted to share with you, Mr. Templeton, that there was no intentional preventing of anyone to speak under general public comment. We did receive one public comment under general public comment. I can't really speak to technical difficulties. I know how hard it is under these remote hybrid hearings to conduct them, but believe me, Mr. Templeton, there was no intentional, it wasn't as if somebody pressed a button to prevent you from submitting public comment. In fact, we anticipated you and your colleagues to come. We waited for you. At the hearing, under the recording, you'll hear me asking if there was anybody else that wanted to speak under general public comment, probably several times. So I just wanted to make that clear.
That's appreciated. Thank you. All right, members, what do you think? Any thoughts on this?
Sorry. Yeah. I mean, I think seems to have been a slow supply of some of the documents, and I think that's been acknowledged at least at one point, and then a no contest plea kind of made it another. I find this file was really complicated to look at, and I just want to say, I think these records are public, they're under our jurisdiction. But if this goes forward, or when this goes forward, I think it would be good to have a little bit more evidence for some of the claims to be carefully considered. For instance, if there are 2 years of agendas missing, just like some kind of documentation of that, other than asserting it, like maybe a photocopy of.
We did show that.
You have a photocopy of the missing agenda?
It's in the one of the amendments, and it was actually in the PowerPoint where I was showing the gap between the two pages.
Okay, I don't know. I couldn't parse it in what I was looking at, but it would be great to just be able, if you're going to say it, to just say, please see, page blah blah blah, so we can just go and
it was
confirm
page 18. It was 2005, and page 19 was 2009 or 2000.
Yeah, right, but that doesn't correspond to the pages I got in our packet. So I know that's a pain, but if you can somehow highlight where that is in your materials going forward, that would help.
Mm-hmm.
I think also.
Well, that was the point of the PowerPoint, to pull out.
Yeah, and then so I totally understand. Also, I definitely saw the one request with the 5-6 items on it. I think you reference that there were other requests at various points in your documentation, but I think if up front you could just be really clear, there was this, verbal request, there was this written request, there, just be very, very clear about it so that we can understand like the requests that we're reviewing. And then, I'm wondering, like with the meeting where you weren't able to speak, if there's any kind of documentation of registering an objection, for instance, during that meeting in any form,
Yes.
or after in any form, like an email to them, or trying to make a comment later, like we wanted to make a comment on this item and we weren't able to, or just anything that kind of helps us see how that happened or when that happened. Would be really great in terms of just being able to like understand what went on here. So I think there's, some documents were definitely supplied slowly. I'm not sure how good the communication was on that. I'm not really, it's not clear to me this claim of failing to maintain or preserve documents in a professional manner, unless I go back and see that there is this real gap of 2 years in the agendas. But anyway, so I think there's like enough questions here that I would send it forward to the full task force, but just ask that the key items in this file really be highlighted and very clearly kind of documented out, because just sometimes it's referenced here, there, and elsewhere, but usually we're used to seeing like, oh, here's when we submitted the request, here we didn't get anything back, or here, was where we tried to, make a public comment, and these are the ways that we were thwarted, even after we said that we weren't able to comment on the item that we wanted to comment on. So that's all I have to say.
Okay. And I don't know if we can do much except move the document request complaint on to the full task force. And I think we probably should also, include a mention that there is this allegation about public comment. I'm not, I'm guessing that this may have been a non-intentional exclusion of these 3 speakers. We don't know, and that's not anyone's fault, but that's a situational
But
problem.
that's why I mentioned too, if there was any attempt to register that we weren't able to speak on this item that we wanted to speak on.
There was, and it's actually in the emails that they submitted includes the emails that we sent, and also the emails from the commission asking why, because we had submitted testimony in writing. And so they were expecting us to come on. And so we're sending emails asking why we can't get on. The commissioners are sending emails.
Like during the meeting? Were those sent during the meeting?
Yeah, so that's it. That's then what they submitted. And then,
if I may, just because we're on this subject matter, Mr. Templeton, if you had come on during the course of that meeting at any time and press *3 to raise your hand, I would have called it, and through the chair, we would have gone back to general public comment. I mean, in other words, if you were late to general public comment, or you were having difficulty getting on during general public comment, if you had called in to the meeting and pressed *3 at any time during that hearing, we would have given you that opportunity to speak under general public comment by going back to it through the chair.
Well, in all 3 of our cases, we had to leave. So once the time slot, we had to go to other things.
So I just want to say, Mr. Tilton, if you get a chance, if you are able to like submit an addendum to this packet where you say these are the allegations and here's the specific evidence of, here's us trying to email, or here's where they responded that they were emailing us during this meeting and we were telling them we couldn't get on, or something like that. If you can just like highlight those documents out, because just so we get 5 days to review like 1,000 or 2,000 pages of material, and if it's buried in there somewhere, it's like we might miss it. So anything you can do to highlight it would be very helpful, because I didn't see where in the emails that was made clear.
Well, the one thing I didn't think I'd hear today was somebody asking for more material, but
well, I mean, I don't want more. I just want the material that is there highlighted, like somehow excerpted, highlighted. You know, sometimes more is less, because we're reading through and we're trying to understand, and it's not presented in an order always where we can understand it. That might be partly our fault in terms of how our files get constructed. I don't know. But anything you can do to like really highlight the relevant information that would help us get to the heart of the complaint.
Yeah. And the significance of it is that it sparked a lot of other things. And so there was a real-time response to it. And how it happened, nobody's ever going to know, but it's important to see how things happen from there. So we'd be happy to point out that sequence.
Thank you. Okay, Member Stein, would you like to make a motion on this to push this on possibly to the task force? I'd welcome it.
I will just say that the records are public and within our jurisdiction, and that we should move this case to the full task force for consideration of, I guess it's 3 items, right? Whether the records were provided in a timely and complete manner, whether there was any exclusion of public commenters from a public meeting, and what was the other one? Whether records have been maintained in a professional manner. That's addressing again
whether the conflict of interest issue would be in your jurisdiction.
Yeah, that's not something
that isn't in our jurisdiction.
Okay.
We are only public records and public meetings, and whether or not records requests were responded to appropriately in line with the San Francisco Sunshine Ordinance or the California Brown Act, and as well as the Public Records Acts. So that is sorry, I'm trying to be really clear. So I have those 3 points, and I guess that is I didn't see anything about failing to post agendas with meaningful item description.
Well, I'm it may be adherence to the ordinance, but I didn't think that actually described the situation, because what occurred was we requested that an item be on the agenda. We were told that if we supplied certain information that it would be, and then it didn't happen. So our right to petition our officials was abridged because we couldn't bring that forward.
Yeah, and again,
and so that would be how I would describe it, because the issue wasn't on the agenda, and we couldn't get on the agenda. And
Yeah,
so we didn't get on the agenda for 14 years.
I don't think that's under our jurisdiction per se, but whether records were supplied, in a timely manner, that's 67.21. Whether they have been maintained in a professional manner, 67.29-7, and then whether public comment was taken at a meeting, able to have that number.
So I think we have a motion, and let me ask if Cheryl needs any clarification on that motion.
Just the exclusion of public commenters from a public meeting. I didn't hear Member Stein. She was talking and then her voice trailed off.
Sorry, yeah. I was just trying to find, I think that's 67.15, public testimony, that every item has to provide opportunity for the public to address it. So I think that's what the full task force should consider.
Okay, so Cheryl, do you have the motion?
Yes, and you're
Okay.
seconding.
I think I will. I think I see a second from
I'll second it.
Wolf. Okay.
Oh, okay, Chair Wolf, Member Wolf.
So now we can go to public comment on this motion.
Give me 1 moment to get myself situated. So, members of the public who wish to provide public comment on this item can hit *3 if you're on the phone to raise your hand, and if you're connected via the application, you can hit the raise your hand symbol. So at this time, I'm waiting to see if there's anybody who would like to raise their hand to speak on this item. At the moment, I do not have anybody listed.
We may not have any public commenters on this item.
Yes, nobody has raised their hand.
Okay.
That should conclude public comment on this matter.
Let's go ahead and vote.
Ready for a vote, Chair Schmidt?
Yes, please.
Okay, Member Stein?
Aye.
Member Stein, aye. Chair Schmidt? Oh, I'm sorry. No, Member Wolf.
Aye.
Member Wolf, aye. Chair Schmidt?
Aye.
Chair Schmidt, aye. Moved by Member Stein, seconded by Member Wolf, that the records are public, that there is jurisdiction, and move to forward the matter to the task force for consideration of 6721 on whether the records are provided in a timely manner, 6715 on whether there was an exclusion of a public commenter from a public meeting, and 67.29-7 whether the records were maintained in a professional and business-like manner.
Okay, thank you. And we will then be moving to the second matter involving Mr. Templeton. When you're ready, Cheryl.
Okay, hang on a second. Item number 7, file number 22028, complaint filed by John Templeton against the Historic Preservation Commission for allegedly violating an administrative code section 67.7, 67.21, and 67.29-7 by failing to post an agenda containing meaningful description of each item of business to be transacted or discussed at the meeting, failing to respond to a request for public records in a timely and a complete manner, and failing to maintain and preserve all documents in a professional manner.
All right, so just having in mind that there's not much daylight between the prior case and this case. It's just that the respondents are different. I would say if you can tell us if there are any differences that you see between the two, it may be that the two cases definitely should be heard on the same date in the future. But if you can tell us if there's anything different about this, because it's against the Historic Preservation Commission. And yet I'm going to say we're going to start first with a presentation from the petitioner, and then we will move on to the respondent. When Cheryl's ready,
yeah, I would say rinse and repeat in terms of what we've discussed so far. The only thing that is worth noting in this particular case is that
excuse me, Mr. Templeton, are you giving testimony now?
Oh, yeah. I'm sorry. She's got to put you on a timer.
Oh, okay. I'm sorry.
I have to put you on a timer. Yeah.
Oh, okay.
Okay. Go ahead, Mr. Templeton.
Yes. What's different about this is that the the chair of the commission was the person that we made the request to. And I guess my observation at the time and since then was that I felt like she was sort of losing the distance between being a commission member and a staff member, because we were asking her to investigate what the planning department was doing, and she was basically acting as an agent for the planning department. So we're making the request to her and, not getting the results. And so it felt almost like a bait and switch, where we said, okay, well, we're providing our information, and then they came back and said, well, but really what you want to do is help us. I said, no, that's not what we said. That's and so the commission, basically, the commission should have been on our side. Commission should have been asking, where's this information? We shouldn't have had to do all this in digging. They should have said, well, what happened? Where's this information? And so, and it's probably beyond your scope, but they just had the CSU chancellor resign because he didn't investigate, complaints. And so that's a very serious issue for us to come forward and say that, since 1968, San Francisco has never advanced a Black property to the National Register. And, and this book, The Bonds of Inequality, basically talks about the links between the banks and the planning department to actually displace African Americans. So there's scholarship behind it. And one of the reasons why we've, really dug into this deeper is to see, what is the continuing legacy of that right now. And so, so our basic point is the commission should have been doing this instead of me.
Okay, thank you. Thank you. Now, on behalf of the commission, Mr. Ionin, are you going to speak on behalf of the commission also tonight, or is there someone else here?
No, I'll be addressing this as well.
Okay. And so when Cheryl's ready, yeah.
Cheryl, you don't have to start the timer. I'm going to make this very short. I failed to see the difference between the two complaints. I've addressed the points in the previous complaint. So I'll just leave it at that. I'll just say basically if you could transfer my comments from the original to this, that will suffice.
Thank you. Any questions? Member Stein, Chair Wolf?
Sorry, I am wondering, what is the relationship of the Historic Preservation Commission to the Planning Department? Like, are these separate entities? Is this a commission within the department? What is the relationship?
Yeah, so essentially the Planning Department acts as staff to the Planning Commission and the Historic Preservation Commission. So I'm the only secretary in the city and county of San Francisco that I work with two commissions. Did that answer your question? So
you're the staff. Okay, so you're really it seems, but two different requests were made to two different arms of the same.
It was actually the same request. The March 28th email actually never made it to staff until it was forwarded from the commission chair. I believe it was originally sent to our commission president, and then she forwarded it on to us.
Okay. Can I ask Mr. Templeton, why do you want to have these handled, or do you definitely want to have these handled separately, or can you see them just being handled together, given that these are two related bodies of the same agency?
Well, that was my preference at the beginning. I guess the Sunshine Ordinance staff said that it needed to be set up as two different things.
Can I just ask Victor, is that, and Cheryl, is there a reason these are being heard as two different things?
This is Victor Young. In general, we separate all bodies into separate complaints. While this one is very similar and justifiably maybe should be combined, we don't make that decision at staff. We leave it up to the task force to make that determination.
Okay. I guess I am wondering from my fellow committee members what they think about just having two respondents be named as the Historic Preservation Commission and the Planning Department, and hearing it as one case.
I'm going to ask a question about this issue to Mr. Ionin. If the commission itself has any kind of records, are those maintained, held by the planning department custodian of records?
Yes, they would be subject to my purview and collection. I mean, if they're on their personal devices that pertain to, work-related matters, then we make that request of them.
Okay. So when you received the copy of the request from Ms. Matsuda, I believe it was your understanding that the reason for that was that any records that they knew about that might be responsive, you would be the one who would have access to those records. Is that fair to say?
That's correct. We would process record requests on the behalf of the Historic Preservation Commission and the Planning Commission, for that matter.
Okay. Well, yeah. I mean, to Member Stein now, I mean, we could combine the two. We could consolidate. Oh, yes. I see a hand from Chair Wolf.
We can't combine them. Our complaint procedure rules don't allow it. Has to be the same complainant and the same respondent. Okay. And it's not.
Okay. Good. Then we have an answer. Thank you.
I would argue that it is the same respondent, but I'll leave that to you. I don't see how it's different.
Are the same people on the Historic Preservation Commission the same people that are on the Planning Commission?
No, those are two separate commissions, but the staff is the same.
It has nothing to do with staff. This is not. Okay. This is it's about the body is the respondent, not the staff.
I understand, okay. Mr. Wolf. I'm just suggesting that they are the same complaint and same respondent.
Okay, we'll keep them separate.
You're on mute, Laura.
Sorry. Did you not say that you're the custodian of records for both?
I'm the custodian of records for the Planning Department, which is staff to both the Historic Preservation Commission and the Planning Commission. But yes, so.
And there's no separate custodian of records for the Historic Preservation Commission?
No, there isn't. That's why I make the argument that it's the same complaint, same respondent.
That is a wrong interpretation. I am sorry.
That's my interpretation.
I understand that, but that's not our rule. Our rule is that
that's fine by me. You guys rule the way you want to.
They're two different bodies. They have two different charges, different jurisdictions, and they're different people. And the complaint is against those bodies, not against the staff. So that's kind of, you're shaking your head. I don't know what you're shaking. I don't know what that means.
But I think that we've made it pretty clear that there's no reason to try to, justify combining the two. We'll just hear them hopefully at the same hearing in the future. But we're not gonna combine, quote, or we're not going to consolidate.
Okay.
But well, I don't. I mean, we could try to, like, if you want to keep talking about that. I don't know if it necessarily is. I tend to agree with Chair Wolf that these, for our purposes, they should be treated separately, because the commission is not a wing of the department, as far as I know. I know that the records are kept by the department. I understand how that works. But we're supposed to be able to deal with the commission as being a separate entity from the planning department for our purposes.
All right.
I would suggest, as a historian, that for the record, 100 years from now, it would be worthwhile just to have as two different cases, just so people know the difference between the two things. So even if it's similar content, but.
Thank you. Members, any other questions for the parties? Nothing from me. And I'm fine with, we go forward with the same motion. But we should make sure that they're heard not simultaneously, but consecutively, maybe.
Is that a motion?
Yeah, is that a motion, Chair Schmidt?
Sure. I make the motion, which is identical to the last motion in the last matter, to move it on the same issues, and to just clarify that the two should be
Heard consecutively, right?
Yeah, heard consecutively.
Okay, I'll second that.
This is Victor Young. I was wondering if there are any members of the public who wish to provide public comment on this matter. You can press *3 to raise your hand, or hit the raise your hand icon on the screen if you are connected via your computer. I will give them a moment to raise their hand if they would like to do so. I do not see anyone's hand raised except for Member Wolf, but so I believe we can public comment.
No.
No public comment, Member Wolf, Chair Wolf. Okay. No,
not chair
no public. But I can still call you that, can I? So let's go ahead with the vote.
Chair Schmidt?
Aye.
Chair Schmidt, aye. Member Stein? Member Stein? Member Stein? I didn't hear that. Member Stein, are you seconding the?
Is she voting aye? You vote.
Aye. Aye.
Aye. Okay, great. Thank you. Member Wolf?
Aye.
Member Wolf, aye. Moved by Chair Schmidt, seconded by Member Stein, that the records are public, there is jurisdiction, and move the matter to the task force for consideration of 6721, whether records were provided in a timely manner. 6715, was there exclusion of public commenters from a public meeting? And 67.29-7, whether records were maintained in a professional and business-like manner.
Great. Okay. let's go ahead with the next matter. We now have two. Thank you to the parties on the last two matters. Two cases with again Mr. Kramer and first against. Let's see. Oh, the first one I think is against the adult probation.
Are we ready to commence?
Yeah, go ahead and call that.
Item number 8, file number 22030, complaint filed by Giselle Robbie and Carl Kramer against Karen Fletcher and the Adult Probation Department for allegedly violating Administrative Code Section 6721 by failing to respond to a request for public records in a timely and or complete manner.
Okay, so first we'll hear from the petitioner. You have up to 5 minutes. We've already, seen all the documentation, but anything you want to add?
Can I ask the parties who will be speaking on this matter raise their hand by pressing *3? Okay, I see them. Give me a moment. Okay, I have unmuted the participants who have indicated that they should be.
Okay, so who will be speaking on behalf of the petitioner?
Hi, this is Carl Kramer. I'm on.
Mr. Kramer, are you ready to begin speaking?
Yes.
Go ahead.
Okay. This is Giselle Robbie is a research intern with our organization, and she had filed a complaint. She filed it on, you'll see on page 547 that she filed a complaint March 29th, and then I think the date that it was filed with Sunshine Ordinance Task Force was April 4th when she got the, and that the initial request was made on their Adult Probation Department's portal on December 24th, which you see on page 550, and also that was emailed on December 23rd to Karen Fletcher and Veronica Martinez. Page 558, the response from Elisa Baeza was at an enclosed, that was on January 10th, and that had attached to it a letter that stated there are no responsive records for your request. Page 558, response from me that the Controller's Office had showed allocations and that to the Adult Probation Department for the Minimum Compensation Ordinance, MCO, but even if there was no allocation for MCO, the cost of doing business increase applied regardless of whether all of the organizations were paying above the MCO rate. And then on, you see on page 557, January 25th, they responded that they did receive allocations, but they do not know how much was that they had paid to each nonprofit. Page 555 and 556 on February 4th, I had sent them a chart of figures that we had received from the Controller's Office showing that the MCO increases for 2019 and 2020 to their department and asked if there was another office that did the MCO calculations for them for the following fiscal year. Page 55, Elisa Baeza referred me to the Office of Labor Standards Enforcement for guidelines on implementation. And page 554, response from me that the Office of Labor Standards Enforcement doesn't calculate funding to nonprofits for departments. Page 553, also a response from OLSE that they do not work on budgetary matters. And that's kind of where we've left it.
All right, thank you. And now we can hear from the respondent side.
Hello, can you hear me?
And who are you, please?
This is Christelle Tullock. I am the Chief of Adult Probation.
Christelle.
And I'm unable to, I think, because we generally use Zoom and Outlook. So what?
Can I just stop you for? Can I just stop you for a minute? Are you giving testimony now? So I have to time you.
I'm representing my department.
Okay, you may begin.
Okay. No, I'm just explaining that I can't show you my face or participate in a more constructive way because of the limitations with.
I was trying to make you a panelist, but it's not letting me at this point in time.
Okay.
My apologies.
No worries at all. So I'm a newly appointed chief. At the time that the original complaints were happened, obviously I wasn't installed in this position, and Chief Fletcher was not actually in our department at that time. She left in August. So I did receive information that all of the inquiries that have been made by the complainants were responded to. It just seems that, and that information was provided, but the nuance to what is being requested isn't something that our department generates, and that we are unable to generate in an aggregate way. And the other thing is just some clarity as to exactly what it is that the complainants are attempting to get at. If we could get more information from that perspective, for instance, are you claiming that my CBOs are complaining to you that there is some discrepancy in their pay? Because I have a response for that as well. Like, on whose behalf are you acting? What are you trying to prove that I could help you to better understand? And that's it from my perspective.
Okay. Okay, we've heard from the parties. Now, questions that might be asked by the members of the parties.
Yeah, this is Member Stein. Oh, go ahead. Sorry. Go ahead.
Member Stein.
Yeah, I just wondered if Mr. Kramer wanted to answer that question of if he can just be very clear about what would he like to see the Adult Probation Department do, or what information would he like to see them have in specific? If you just want to answer that question so that it's clear to the Adult Probation Department.
And that's a question to Mr. Kramer, if you are still available to answer.
Yeah, sorry about that. I had muted myself. Yeah, to answer that question, I think I heard it also as kind of a question of motives. What was the reason we're asking for this information? There's, I think, a very overriding
public interest in and what is happening with money being allocated for workers' wages. The Controller's Office recently held a hearing and issued a report on that the city is facing a real critical period now of such a huge turnover of staff in the nonprofit organizations that are providing critical services to the residents of San Francisco, that they're really seeing an implosion of the social safety net in San Francisco. There's like, there's $1.2 billion that is being spent on services that are being provided by nonprofit organizations. And but those organizations aren't receiving enough funds that they can provide the kind of wage increases that retain experienced workers, and at this point are facing a crisis in even being able to attract people into those jobs. What the Controller's Office study also brought up is that they're finding it very problematic in kind of accountability on whether the money that is being allocated for workers' wage increases are ever reaching those nonprofits and actually getting into the pockets of workers. And a number of nonprofits did say and are complaining, at those hearings that the Controller's Office had, was that they were not receiving money that was being allocated for the cost of doing business increase, which is, to clarify that, is the money that is was, for example, for this fiscal year was allocated by the Mayor's Budget Office as a 3% increase of the overall general fund budget for nonprofits. And so that's money to, to deal with all inflationary pressures. But that is also to include wage increases. That's the CODB, the cost of doing business. The minimum compensation ordinance allocations are a little more targeted to being specifically for wage increases, both for bringing up the wages for those who are below the minimum rate, to bring it up to the minimum rate, but to also apply to what the Controller's Office calls wage compaction, that is raising wages for those above the minimum rate up to $22 per hour. And so the Controller's Office, they had documented that they had allocated money for that in 2019, 2020. We're not getting any, responsive documents from Adult Probation Department to show what was done with that money. There was also allocations for the cost of doing business increase in that year, and the allocations in the following year, and also allocations for this current fiscal year. And we are not getting any documents about what's being done with that money.
So you're saying the Controller's Office is telling you that they're not getting information from
I need to just, Member Stein's asking questions here.
Yeah,
so
sorry. Yeah. So thank you. Thank you, Mr. Kramer, for making it clear what it is that you are looking for, which to me, it just sounds like understanding how the MCO and CODB monies are being dispersed to the recipients that they are meant to be dispersed to. And you're looking for some kind of line item that shows that is my understanding. Correct? And basic, is that correct?
That's correct.
Okay. All right, and that's my only question.
Okay. Oh yeah, I'm sorry, Chair Wolf, your turn.
Yeah, I just want to remind us and the parties, especially the complainant, that there's no need to provide us with the intent of why you're asking for these records. All government records are public records. You have a right to them. We're here, purely to try and help resolve issues around withholding. And so with that, I have a question for the respondent. When you receive your funding and you receive you put out maybe you put out a NOFA or a notice of funding availability, or you have an RFP, or I don't know what your process is for grant making or any other kind of financing to your for your contracts. Do you not keep a list of how that money is distributed? Or do you keep a list?
Do I speak now?
Yes, that's a question.
Okay. I haven't been in one of these sessions before, so
that's all right.
Forgive me. But just to clarify, I'm not questioning intent. Obviously, the public policies are very clear. My question is, how can I help you get the information that you're looking for? Well, intent is not that. And then the other piece of my question about, are you speaking on behalf of my CBOs? Because I know the relationship I have with my CBOs. I know we do pay above NCO, and then I know what's in my budget ask. So if there's some disconnect between the direct relationships that we're having with our CBOs, and it's unclear to me if you're speaking on behalf of my CBOs. I'm just trying to get that background for my own edification. But intent is not in question.
I'm just asking the request that was put to you by the complainant was to provide them with a list of allocations to the nonprofit organizations that contract with you through these two programs. That's all he's asking for 2 different fiscal years. So I don't know how else you can help by providing those lists.
Right. And so, like I said, all of that preceded me. But when I talked to my staff, that's what I learned about trying to understand and get more clarification as to what is specifically being asked. Because my understanding and the way that it's being requested, they can't aggregate that data, and it's not something that we generate. And so when you're responding to PRA, if it's not something that you routinely generate and you're put to task to create a specific report or do something in addition or different from what you normally do, then a response that information is not readily available is appropriate.
Yeah, that's not, to me, that's not acceptable answer. That sounds like somebody.
It's a legal answer.
Well, I understand that, but the reason why it's unacceptable is because the information is public if you have it. And if you don't,
we don't gather that.
You're not creating a new document. You're basically doing a query of that information if it's in a database or something. And
that's what we don't have the information gathered in the way to which they're requesting. But if they provided more information, I could work with my team to figure out how to answer their question.
I'm sorry. It's a very, very clear in the complaint summary as to what they're asking for. I'll read it verbatim. The request is for the allocations of the nonprofit to the nonprofit organizations to which your department contracts for the additional minimum compensation ordinance, MCO funds, and the cost of doing business, COBD funds, as separate figures for fiscal years 2019 to 2020 and for fiscal year 2020 and to 21. We are looking for the figures to each specific nonprofit. I don't understand why that is complicated.
I never said it was complicated. I never said that. What I said to you was the feedback that I received from my finance staff is that in the way in which the original question came to them, it's not a routine report, or it's not something that we aggregate to that request. So
how do you then make a financial report to the controller?
Well, we report to the controller's office, and in every way in which we report to the controller's office, it's routine, it's already established.
Right, and
So
doesn't that include how much money doesn't that include how much money is dispersed to each of the nonprofit organizations?
Of course, and I believe that is why the complainant was referred to go to the controller's office to receive that information, because they hold those records.
Yeah, but you provide those records to them. So it's
the controller's office manages all of this, all of the agencies. So it's the information is there and available through the controller's office. And I read documents in which my staff did refer them there. And I'm understanding that whatever information they received from the controller's office still didn't satisfy. But, you know, like I said, I will take it back to my team. But if there are more details or something more specific that they want, we're more than happy to provide. And like, you know, our CBOs are paid above MCO. We're in a budget process right now where we're asking for even more of a salary increase for our CBOs, and our CBOs have never raised any complaints to us from that perspective. So that was the other reason why I asked that question. So
I think can I just say, I think what's at issue here is that there is some, at least with the MCO, some recent, you know, it's a recent legislation that asks different departments to make sure that they include an increase that's pegged to like cost of living increases in their payment to their CBOs. And Mr. Kramer and his organization have said that this needs to be sort of a line item in the budget. And so far, almost all the public information requests that he's made to different departments, they haven't put it as a line item in their budget. They haven't sort of shown how they've separately made sure that cost of living increases are there or the required MCO increases there. And I think part of the reason that he's making these requests, even though I know intent doesn't matter, I think he's trying to make different departments aware that this is what they believe should be done, but they're not doing it that way. So the information doesn't seem to be there because they're not doing it that way. And I think part of his request is about advocacy, that, you know, that these be separate line items to make sure that nobody is caught short, sort of in budgeting what what employees of CBOs should be paid, you know, at the end of a fiscal year. That's my understanding from the series of complaints that have come through. So you have this conundrum that you have, you know, a certain legislation which is asking that they consider these costs of increase, and then they're saying that they've considered the costs of increase, then they're paying more money or they're paying over the amount that they need to, but it's just not a line item. So the record doesn't exist that shows that they've created this, that they've particularly taken the MCO legislation into account, for instance. So I think Mr. Kramer wants to communicate that, you know, that there is an intent here, that he wants to communicate to these agencies, and they're not our departments, but they're just not necessarily following the MCO legislation in the way that his organization believes it should be followed.
I think we're getting a little too much.
It's maybe in the weeds, but I'm just,
I need to like stop the argument here, because this is not the time for debate.
I only say it to say that I don't believe these records do exist. Yeah.
And
Okay, so you,
like I
yeah,
said, our budget request
members, I'm
includes
sorry,
increases,
I have
and
to
all
stop
of our
you. I have to
NCOs are
stop
paid
you.
above NCO.
Please, I need to keep an order here. There was no question, and so we're just trying to figure out if we have any questions for Member Stein. Did I did you have further questions?
No, I'm done.
Oh, okay.
I'm ready to make a motion.
And I just had one question for the parties, which is a question to the respondent. Is it your understanding that your department provided every document that would be responsive to the request as made to your department? That was every document that was held by your department.
Like I stated, I'm newly appointed to the department. However, I do know the history of the department's relationship with its CBOs and how we rely on them to carry out our mission. And in looking at the documents and in speaking with staff, the two staff that received this initially are no longer with the department. But what we do know is once the staff were at a point where they knew that they couldn't aggregate that information, the next step was to refer them to the controller's office.
And that's what they did, is refer them?
Mm-hmm.
Okay.
Yeah. And they were referred.
Okay, thank you. No further questions. Member Wolf has a motion. Chair Wolf has a motion.
I wonder if I have a chance to respond.
Unless we had questions, I think this is not the time for questions. Member Wolf, Chair Wolf.
Yeah, I move that find the records public and within our jurisdiction, and recommend it for hearing at the full task force.
Okay, we have a motion, and I'll be happy to second that. Whenever you're ready, Cheryl, we may have public commenters. Victor.
Yes, this is Victor. I believe we only have one other member of the public online with us. If you would like to make public comment, you can press *3 to raise your hand. They have not raised their hand, so I believe we don't have any additional public comment on this matter.
Okay, I think you're right. Let's go ahead with the vote.
I'll just say, just the last point, this will go for a hearing. We'll have plenty of opportunity to discuss the details during the hearing. So just wanted to, so we don't prolong it here. Okay, thank you.
Thank you.
Are we ready for a vote, Chair Schmidt?
Yes, we are ready.
All right, Member Wolf?
Aye.
Member Wolf, aye. Chair Schmidt?
Aye.
Chair Schmidt, aye. Member Stein?
Aye.
Member Stein, aye. Moved by Member Wolf, seconded by Chair Schmidt, that the records are public, there is jurisdiction, and to forward the matter to the task force.
Next matter, when you're ready.
Okay, that's item number 9. Item number 9, file number 22031, complaint filed by Giselle Robbie and Carl Kramer against the City Administrator Carmen Chu and the Office of the City Administrator for allegedly violating Administrative Code Section 6721 by failing to respond to a request for public records in a timely and or complete manner.
Okay, we will hear from the parties. The petitioner first, and that may be Mr. Kramer. You have up to 5 minutes when Cheryl indicates.
Mr. Kramer, you ready to begin?
I'm ready.
Go ahead, sir.
Okay, thanks, Cheryl. Yes, just also point out, this was also another office that had a change in personnel, and the responses I was getting from the former finance and planning director, Adam Wynn, was very, very friendly. He was trying to be helpful. Seems another kind of situation of the office not really being clear, kind of on how things work, and for needed more clarification. So I think we're taking the opportunity now to kind of clarify how these things work. The initial request was sent on December 23rd. You see that page 584, email that was sent to Carmen Chu and also to their Sunshine Request email address. And January 4th, they released documents. January 8th, they responded that one of the documents was just a duplicate of the other, not January 11th, they responded with another document, and then asked for more details, more clarification, on April 6th they did update information, and it kind of went back and forth in the email exchanges on kind of clarifying the request. So the information that they sent on the amounts of funding for the minimum compensation ordinance in fiscal year 2019 to 2020 was funding to 4 programs: Grants for the Arts, Immigrant and Language Services, Labor Standards, Treasure Island Development Authority. Each of those programs funds different nonprofits. And what we want is the funding increases to those nonprofits, not to the programs. The information, the spreadsheet they sent for the fiscal year 2020 cost of doing business increase, they sent information was the amounts of funding to the community-based organizational services and professional and specialized services. And again, we want to see the funding increases specifically to the nonprofit organizations. And then for fiscal year 2021, the chart they sent showed funding with columns that had a project code, activity code, authority code, and account code, which means nothing to us. We want the names of the organizations that are associated with those codes. That's it.
Thank you. All right. And next we can hear from the City Administrator's Office. With Cheryl, you're ready.
May I get the name of the City Administrator?
This is Vivian Poe, a representative from the Office of City Administrator.
Okay. Are you ready to begin your testimony?
Sure. Thank you.
Go ahead.
Good evening, everyone. My name again is Vivian Poe. I'm representing the Office of City Administrator and City Administrator Carmen Chu tonight. So we would like to respectfully deny that the allegation about not providing requests in a timely or incomplete manner. We have been responsive to the requester, as Mr. Kramer kind of recapped kind of the timeline that we have been back and forth on this topic, and we've been successfully provided him some documents that we have for a couple of times. So we have provided him spreadsheets before, and then he mentioned about needing some clarification on coding. So we actually went quite above and beyond and created a new Excel spreadsheet for him and his organization regarding the increase of funding for each of the nonprofit under the different programs and divisions that are under this Office of City Administrator. So we provided the best information that we can, trying to kind of really based on what we understand from Mr. Kramer and his organization, what they're looking for. So we provided that information to our best kind of ability, which shows each of the nonprofit, how much they receive from year to another year. However, the information that he asked for as a breakdown of specific MCO and CODB, I have double and triple checked with our subject matter expert in the accounting and budget team that this is information that we don't currently have, so that's why we were not able to provide it to Mr. Kramer and his organization.
Thank you.
Thank you.
Okay, members, questions?
I just have a question for Mr. Kramer, which is, do you believe that this information is out there and you've in some documents that you've not received, or do you just believe that this information literally has not been generated or taken into account?
Well, I guess just to maybe to address something you'd said earlier, I know that for previous years we've filed more complaints. We're finding now that most of the departments are responding back with the information we're seeking, not finding it a problem to provide that information. And so it's now just becoming, a few outliers. I believe the information is there. I mean, if you're handing money over to some organization, there's got to be receipts someplace. There's got to be something that says that we're giving you this money because this is what is been budgeted by the mayor's office for a cost of doing business increase. I certainly think the mayor's budget office would want all the organizations to know that that they're doing their part in providing additional funding to nonprofit organizations. It just seems kind of ludicrous that those kind of records would just vaporize.
Okay, thank you.
I have no questions for the parties witnesses. It looks like we have a question from Chair Wolf.
Question for the complainant, Mr. Kramer. You repeatedly say that you're looking for the increases from to the CBOs from these two funds, but the language that you use in your request says that you're looking for the additional funds. Are you using those words interchangeably?
Let me double check.
Page 584.
584.
You included the original request dated December 23rd, 2021 at 8:53 p.m. to the city administrator.
Yes, I see that. Additional MCO funds and cost of doing business funds. I did see that kind of interchangeable with the increased funds to nonprofits.
Okay, I just want to make sure, because government can be very exacting, and an increase, it may not be considered additional and vice versa. So I want to make sure that we're talking about apples to apples here.
Yes, and I think the idea was that specifically increases that were as from the MCO allocations and increases that were the cost of doing business increase.
Okay.
Increases.
Thank you. And Ms. Poe, does the city administrator, in receiving reports from a department, from any of these departments, do you not receive a report like in a spreadsheet, one CBO after the other, and how much money got allocated from a specific fund? I mean, is there some regular accounting method?
From what I understand from our accounting and budgeting team is we do have a summary of the funds that we receive for MCO or the COBD funds as a summary, and then we disperse those funds to each of the nonprofit. But what we don't have is when we distribute to the nonprofits, those we have the amount that we distribute to the nonprofits, and that's what we provided to Mr. Kramer and his organization, the year-to-year kind of increases that he can see, but we don't have the specific breakdown of what those increases are and how much of them are contributed to MCO or COBD.
Let's look at kind of the chain of command, so to speak, all right, the process flow. Okay, is it your office that cuts the checks to the CBOs?
I believe so.
Okay, so when you have to submit requests for disbursement, don't you have a list for delineating each and every CBO and how much they're going to get? And somebody has to make that decision.
We do have that information as a lump sum, so that's what we provided in our spreadsheets.
Lump sum for all the CBOs or for each individual one?
Each of the individual one. That's what we provided.
Right. So are you not able to provide Mr. Kramer with that report?
We did provide that report to him, to each of the organization, how much they're receiving.
Okay, then Mr. Kramer, please answer, what more are you looking for, or what didn't you get that you were expecting?
I think she's referring to like an overall budget to each nonprofit. We're looking to what was the increases for MCO and cost of doing business. And we'd like to see those figures separated, but if she's saying, they don't separate them, okay. But
well, I'm suggesting that they have to be separated, because otherwise, how is the city to know who to cut a check to? There's got to be some breakdown per CBO on what those additional funds, how much the check is to be written out for. There has to be a request for that. So that's why I'm seeing maybe we could get this resolved here. And if so, it would save everybody a whole lot of time. Ms. Poe, are you following what he's asking for here and what's in his written request?
I believe so, and I think the challenges here is we are able to provide how much each nonprofit receive and the increase per year as the contract as a whole. But I think what Mr. Kramer and his organization is trying to get is the specific amount that is allocated for MCO and separately for CODB. So we don't have that broken down.
You don't have that broken down. How do you then determine what each CBO is going to get if on an increase?
I do not have like all the details on that, but from what I understand is other than the MCO and CODB, each nonprofit may get a different amount other than these increases, depending on what their contract would look like, what are their deliverables are, what are they committed to do for the city. So it can be a variable kind of reasons why there are increases other than MCO and CODB. But we did give the summaries of all of them. We just don't have a way to break it down to each nonprofit about summaries.
I'm going to ask one last question. Hopefully you can answer it. Who makes the decision, or how is the decision made on the increases from these two funds to the CBOs?
I do not know the answer for that question, but it is something that it is a fund that gets to our office, and we do have that summary, as I mentioned, from how much we get from year to year for the purpose of NCO and CODB.
Okay, and the primary is the city administrator, the primary point of responsibility for these disbursements?
We're responsible for the departments under us that would have program with nonprofits.
Okay, and
department differently. Yeah.
Okay. All right. Very good. Thank you. That's all I have.
Okay. No questions for me. So we can come up with what we want to do with this, keeping in mind again that we're contemplating whether to send it to the task force so we can see if we want a motion. Yes.
I'll move to find that the records are public and it's within a jurisdiction to recommend it for a hearing to the Sunshine Ordinance Task Force.
Okay, thank you. Member Stein.
I mean, I agree with that. My concern is that I don't think these records exist, but I would agree that were they to exist, they would be public and under our jurisdiction. So I'll second it.
Yes.
I'll just add that I think we should note for our presentation to the task force that what is missing from this particular process. What's missing is the particular process for tracking the additional or the additional funds over and above what the baseline or the regular funds that are distributed to the CBOs, and that somebody has to make a decision about what those increases are, or there's some formula that the city administrator uses to be able to come up with how much each CBO is supposed to get. Is it a standard formula that goes across the board, like a COLA, or is it based upon performance for each CBO, or is it based upon need for each CBO? I think that is understanding what the exact. I think the complainant is asking for that, at least that granular information. And if the city is providing additional funds, then there's got to be some kind of accounting for it. And it's, unfortunately, it was not presented here. And that's why I'm requesting this to go before the task force.
Ms. Leger, when you're ready. Well, actually, yeah. Mr. Young, we can have public comment.
Yes. If We have one person still listening on the line with us who is not part of this hearing. If you'd like to provide public comment on this matter, please let us know by hitting *3 and raising your hand. Okay, I see no indication of a raised hand at this time.
Are we ready for a vote, Chair Schmidt?
Yes.
Member Wolf?
Aye.
Member Wolf, aye. Member Stein?
Aye.
Member Stein, aye. Chair Schmidt?
Aye.
Chair Schmidt, aye. Moved by Member Wolf, seconded by Member Stein, that the records are public, that there is jurisdiction, and to forward the matter to the task force for hearing.
Next item when you're ready.
Item number 10, announcements, comments, questions, and future agenda items by members of the complaint committee.
Nothing for me. Nothing?
Nothing from me.
No actions taken.
No actions taken.
Right. Shall we move on to the next item?
Yes.
Item number 11, adjournment. I have 9:10 p.m.
Move to adjourn.
Second. Third.
Third.
Thank you.
Thanks, everyone.
Sorry I had